to the live. This your boy 10 toes down. Love to get it in, you know what we do. And I want to say thank you everybody for joining the live. Choose like the live, comment. If you think they're guilty, not guilty, or it's gonna be a hung jury. Please share this video. Hit the post notification button so you know when I go live. Please subscribe to the channel. This your boy Down. Let's get it in. We about to start. We about to start. You know what we do. It's time to get it in on the big show.
Thanks for accommodating us. I really appreciate it. Always nice to see you. For a little bit.
Okay, well, whoever takes your place. Yeah, you can tell the rules. You only could start filming when he goes on record. And anytime we go off a record, you have to audio and to the wall, and the audio has to be off. He's not gonna say it. He's not gonna say it on record. Basically, it's when say if we're breaking for lunch and he's giving the jurors their and we start taking and then I get up to take them out. You have to turn it off. You can't get the jurors' faces. You're not allowed to get any of the jurors. But anytime they're off record, you're not supposed to be filming. Okay, thank you.
Which one?
There's back one right before this.
The slide? You don't know what? It's my argument.
He objects to everything you say, I think.
I mean, it's my argument, so.
Oh, he's clearly wrong.
He still objects to it.
Everybody gets a lot of, we all get a little extra credit here.
I'm sorry about yesterday. I told people they wasn't gonna have court today. I apologize. My mind was somewhere else. I was thinking about somebody, another trial, not this trial. But we're gonna get right back to it just like that. My bad. Sorry about that.
You ready, dog?
These are directly from evidence, so.
Yesterday he was in his jail. I don't know why, but yesterday he was in his jail clothes.
Why, thank you. That's it. Do you have a
Find your own recollections, but my recollection and are we ready to go on the record?
Yes, Your Honor, good morning.
Yes, sir.
Morning. All right, so we're on the record, State of Florida versus Williams, Boatwright, and Newsom. Parties present, jurors are absent. We went over yesterday the instructions, and I have the final packet, which is the one we agreed to with the page numbers, so that's ready to go. All the parties have indicated the amount of time that they're requesting. The defense, I guess, had an opportunity to look at the state's PowerPoint,
Yes.
and you had an opportunity to look at Mr. Kimlock's
Pictures or
PDF.
PDF, not PowerPoint.
Yes.
Thank you. And I heard there was some objection to Mr. Padilla's closed?
Yes, you heard correct. Mr. Padilla, I believe, he's indicated that he wants to show the jury transcripts, portions of transcripts. I would object. That is improper, to show transcripts. If they are to rely on testimony, it's to be of their own memory as opposed to transcripts. Even when we do readback, we don't show them transcripts. So I would argue that that is improper for closing.
Judge, I would argue that it's actually the norm. I do it all the time, and I put it up on for the jury to see. The actual transcripts, I don't intend to show anything objected to or anything sidebar, but other than that, it's just trial testimony.
Here's what I will do. I will allow you to show that the stuff that you have, you shall not refer to it as a transcript. You shall not refer to it as the official transcript or the recorded transcript or anything else. But if you say, jotted down and typed out the stuff, and as long as you preface it with, of course, you have to rely on your own recollections, but my recollection is this question was asked, you know, if you present it that way, then I don't see any difference between if you'd done that or if you just jotted it down on, let's say a yellow pad.
Okay.
But I don't want it referred to as an official transcript, or this is because again, they're supposed to rely on their own recollection, and the next thing I don't want is, can I have a copy of that transcript?
I understand.
Judge, if I could ask Mr. Padilla to identify which transcripts of which witnesses?
I'll send it to you.
I think it's a trial transcript that he's been ordering every day.
Right, but
Okay, I'll figure it out.
Okay, but again, with those limitations understood, I think it's fine. All right, anything further?
nothing from the state.
No, Judge. No, Judge. No, Your Honor.
All right, very good. We are ready to get underway then. Let us bring them up.
Jurors are entering.
Let's get back to it. Coming on in. But it's a hard job to get through because we got short order evidence and all that shit there for a long time. You know what I mean? You gotta sit there just like you a prosecutor. You did them there. You can't move, you can't walk around, you can't do nothing. The only one allowed to move is the state's attorney and the lawyer. So everybody else gotta sit there, like really sit there and not move until one. That's a lot of shit. Big thing.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. Ladies and gentlemen, good morning. Welcome back. I trust all of you were able to follow the court's directions. Very well. All right. We've now come to the point in the case where both the state and the defendants have rested their cases. The attorneys will now have an opportunity to present to you their final closing arguments. I want to remind you now, as I have throughout this case, that what the attorneys say is not evidence. However, do listen closely to their arguments to you. They will be commenting upon the testimony that you've heard and the evidence that has been presented in this case. They, as you, will be recalling the evidence in the case. Now, none of these counsel would intentionally try and mislead you. However, should their recollection of the evidence differ from what your recollection is, you must rely on your own recollection. Each side has equal time to argue to you that the state is entitled to divide its time between an opening closing argument and a rebuttal argument after each defendant has had an opportunity to argue. So with that, State of Florida, you may close.
Thank you, Your Honor. Good morning. This will be one of the final opportunities that we get, Ms. Buckaloo and I get to speak to you. So we first want to thank you for your time and attention. This case wasn't easy. We asked you at the beginning to commit your time and your attention, and you've done that. And I think on behalf of all parties, we thank you. This is the opportunity that we're going to get. We talked about a lot of hypotheticals at the beginning when we were going through jury selection. But this is the opportunity that we're going to get to actually talk about the evidence that you've heard and how it intersects with the law. Okay? And so I believe at the end, we'll be able to come to the same conclusion, which is guilty as to all three defendants. But let's go through everything. I first want to talk about the law that you're going to hear regarding principles. You'll get instructed on all of the law that I'm going to go over by Judge Usan. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done, okay? And the defendant did some act or said some words which was intended to and which did incite, cause, encourage, assist, or otherwise, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. So that's what the law is. And you'll recall at the beginning when we talked to you at voir dire, all of you said that you would be able to follow this law. So now is the time that the state of Florida is asking you to do that, to follow this law. Let's talk about how this law, though, is applied to the facts that you've heard in this case. For example, the defendants, and I say plural defendants, renting the Dodge Journey together the day before the homicide. That would be a way that the law is applied because they had to assist each other. You'll recall, Dietrich Williams provided the person who actually rented it. Then Michael Boatwright with Robert Allen went to go pick up the car. That's an example of assisting each other. Going together to Reba Motorsports to purchase the mask, okay? They went in the Dodge Journey. That's another example. Inside the Dodge Journey, you'll recall, they had everything that they needed to rob and kill the victim. There were masks, there were firearms, they were ready to go, okay? And that's a way that they assisted each other, encouraged each other to help commit this crime. Another way, Williams and Allen confirmed that the victim is inside Reba Motorsports. Two of them remained inside the Dodge Journey, Trayvon Newsom and Michael Boatwright. Stayed inside the Dodge Journey while the other two go inside to the Reba Motorsports to confirm that the victim is there. That's another example of how the principal theory is implied because they're all assisting each other. Lying in wait for the victim together, waiting for the victim to exit Reba Motorsports. That's another example of how the law is applied to these facts. They planned and executed a coordinated attack on the victim. Think about it. Which we'll look at clips from the surveillance video, when you see the Dodge Journey very quickly cut the victim off, that's the first coordinated part. Second coordinated part, two of the gunmen quickly jump out in a blitz fashion, coordinate, go to each side of the car. That's another planned coordinated attack. That's assisting each other, okay? Defendant Williams driving and cutting off the victim so Boatwright and Newsom can quickly jump out to catch the victim by surprise. That's a great example of how principals assist and encourage each other to commit the crime. Williams waited for Boatwright and Newsom to rob and kill the victim. When the two gunmen jump out of the Dodge Journey, Williams didn't drive off. He's waiting for them. That's to assist them to get away. So now, after they've just shot and killed the victim, what does he do? He assists them by getting away so that they can evade detection. And he quickly drives off. That's one of the ways how, even though, for example, Defendant Williams is not the shooter, he can still be held responsible like the shooter because of all these things that they did together to assist each other to commit the crime. Boatwright approaching the victim's side of the car at gunpoint, while Newsom approaches the passenger side at gunpoint. Think about this. Why is that? The victim can't get away from either the driver's side or the passenger side. He can't go forward with his car because Williams blocks him off. So the three of them are coordinating an attack to be able to rob and kill the victim in that moment, assisting each other. And ask yourself this: would Dietrich Williams have been able to commit this homicide and armed robbery without Michael Boatwright and Trayvon Newsom? I don't think so. Would Michael Boatwright have been able to commit this homicide and armed robbery without Dietrich Williams and Trayvon Newsom? Would Trayvon Newsom have been able to commit this homicide and armed robbery without Dietrich Williams and Michael Boatwright? If you're able to answer each question as no, then you're applying the principal theory correctly. Because each of them, Dietrich Williams, as a driver, he would not have been able to approach both sides of the car as an armed gunman. He needed them in order to commit this armed robbery and homicide. Michael Boatwright needed his co-defendants to be able to rent the car, to be able to drive off. He couldn't have done that by himself. Trayvon Newsom, he's the other gunman. He needed a second gunman to approach the driver's side. He needed a driver to get away. He needed assistance to rent the car. These are all things where they're acting together as principals to one another. You're also going to get an instruction, I believe it's on weighing the evidence. And these are questions, it's not an exclusive list, but these are questions that you can ask yourself as you're thinking about the testimony that you've heard, the exhibits that you've reviewed, the surveillance that you saw, and the things that you've heard at this trial. Did the witness seem to have an opportunity to see and know the things about which the witness testified? That applies to, for example, all the eyewitnesses, how close they were in proximity to the crime. How about the witnesses that weren't at the homicide? Like, for example, Tennell Carter, who knows the co-defendant and was able to testify because she was engaged to him at one point. Did she have an opportunity to know about the things to which she testified? Did the witness seem to have an accurate memory? That goes to, did they have to be refreshed? Were they impeached? Things of that sort. Was the witness honest and straightforward in answering the attorney's questions? So, if I asked a question, did I get a straightforward answer? Or was the witness delaying or combative with me? Those are the types of things you can think about and look for. Did the witness have some interest in how the case should be decided? So, for example, that would be a Robert Allen, who is a co-defendant who has pled guilty in this case and is awaiting sentencing. And so you can consider that as part of his testimony. But consider this as well as you're thinking about his testimony. Think about all the things that corroborate his testimony. And so you can decide if you find him credible or not based on the other evidence in the case. Does it agree with his testimony? Does the witness's testimony agree with other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or any other benefit in order to get the witness to testify? Example, Robert Allen. his testimony about whether or not he received a benefit for his testimony if he received a deal from the state. Even if you decide, you know what, he probably is testifying because he wants to save his own skin, I implore you to still look at the other evidence in the case. Does it agree with it? Is it corroborated by other evidence that you'll hear and that you've seen in the case? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? You'll recall, and we'll talk about it in detail a little later, that would be, for example, when Trayvon Newsom threatened Robert Allen while he was on the stand. That's a way that you can apply that. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? That's the type of evidence that we talk about when it's called impeachment. Did the witness give some other testimony at some other time that conflicted with what they told you? Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? That would be an example of if the witness told you that they are a convicted felon. You could consider that as part of their credibility. So let's talk about what the law is regarding first-degree murder, because it is the primary count that you'll be deliberating on. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, José Onfoy is dead. I'm going to go over the counts and I'm going to talk about how the state has proven them. 2, the death was caused by the criminal act of Dietrich Williams, Trayvon Newsom, Michael Boatwright. When you get instructed on this law, it's going to be separated out. But for purposes of talking to you right now, I put those three together. So that's the second element. And 3, there was a premeditated killing of José Onfoy. So the thing about what I'm going to talk to you about with respect to first-degree murder, there's 2 ways that we can prove first-degree murder to you. 1 is premeditated murder. The second is felony murder, which I will get into shortly. To prove the crime of first-degree felony murder, the state must prove the following 3 elements. It's going to be the same as premeditated murder. 1, José Onfoy is dead. 2, while engaged in the commission of a robbery, in this case I separate out, Dietrich Williams caused the death of José Onfoy. And this is where also, when we talk about the principal theory applies. Because for number 2, it doesn't have to be that he actually caused the death. As a principal, were his actions with his co-defendant the cause of José Onfoy's death? That's how you apply the principal theory. José Onfoy was killed by a person other than Dietrich Williams. In this case, we've alleged from the beginning that Michael Boatwright is the shooter, but both Dietrich Williams and the person who killed José Onfoy, which would be Michael Boatwright, were principals in the commission of the robbery. So that's, again, that application of principal theory. Now, one of the things I want to talk to you about, premeditated murder and felony murder.
I'm going to just pause real quick. Yeah, she's a great state's attorney, because if you really look at it, she just taking her time, speaking clearly, not saying it all fast, but nobody can understand her. She, you know what I mean? I know I've been watching this for a long time. Like, I watch over 1,000 trials, so I know that you get some lawyers, when they do their little closure arguments, they be all fast with it and all that, but she's taking her time slowly, so she'll make sure they can get everything, and she can put everything in there, because I think they probably got like an hour and a half a piece to close the arguments. Most likely it's an hour and a half, no more than 2 hours a piece. So let's get right back to it real quick. It's your boy 10 Toes Down. Please comment guilty, not guilty, or hung jury. Please share this video, like this video, and subscribe to my channel. Please, thank you very much. Let's get right back to it, just like that.
There's 12 of you that will be deliberating. If 12 of you decide that the defendants are guilty of first-degree murder, then you can vote and deliberate and say that they're guilty. You don't have to agree on whether it's premeditated or felony murder. So 6 of you could decide, I think it was premeditated murder. And the other 6 of you could decide, I think it was felony murder. They're still guilty of first-degree murder. Okay, so that's the option that you have and that you can take. Now, Jose Envoy, I'm gonna spend a lot of time for both felony murder and for premeditated murder, the second and third elements, okay? Because when we get to Jose Envoy is dead, that is something that, if you'll recall, Jose Envoy's aunt identified him as the deceased person in this case, and we'll talk about that. That's an important element that we have to prove, and I submit to you that we did, but there's a lot of evidence that is, that works together to prove elements 2 and 3, okay, under first-degree murder. So I'm gonna spend a lot of time talking about that. This one is with respect to Michael Boatwright. It's a little different because he's the shooter. With respect to the elements, Jose Envoy is dead. While engaged in the commission of a robbery, Michael Boatwright caused the death of Jose Envoy. So there's 2 ways that you can find that we've met that element. Number 1, Michael Boatwright is the person that jumped out the car as the armed gunman and was in the commission of the robbery of trying to steal the necklace off of Jose Envoy's neck. And also, if you'll recall, the co-defendants actually stole $50,000 from the victim. Okay, so whether you say it's in the commission of or it's premeditated, it's still element 2 is proven. And while in the commission, while engaging in that robbery, they killed, or Michael Boatwright killed the victim. So that's how element 2 is applied. And Michael Boatwright was the person who actually killed Jose Envoy. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. So remember, when I said 6, it could be 2, it could be 1 of you decides it's first-degree premeditated murder. And the other 11 say, you know what, I don't believe that the state proved intent, but I believe that during the commission of the robbery, Michael Boatwright killed Jose Envoy. It's still first-degree murder. This is as to Trayvon Newsom. Number 1, and the elements are going to remain the same for each defendant. Number 1, Jose Envoy is dead. 2, while engaged in the commission of a robbery, Trayvon Newsom caused the death of Jose Envoy. 3, Jose Envoy was killed by a person other than Trayvon Newsom, which is what we've alleged, and I believe that we've proven, because Michael Boatwright is the killer, is the shooter. But both Trayvon Newsom and the person who killed Jose Envoy, which would be Michael Boatwright, were principals in the commission of the robbery. Again, there's that principal theory. And remember those 3 questions that I asked for you to ask yourselves. Could Trayvon Newsom have done this without Michael Boatwright and without Dietrich Williams? Could Dietrich Williams have done this without the other 2? That's how you apply this. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. Count 2. You'll also get to deliberate regarding armed robbery. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Dietrich Williams took certain property of value from the person or custody of Jose Envoy. So you'll recall, with respect to the principal theory, Dietrich Williams doesn't have to even be at the scene of the crime. He doesn't have to be the person that reached into the car and grabbed the money from Jose Envoy. As a principal, if you find that the law is applied and you follow law of principles, then he is treated like his other co-defendants. And so did, by his actions and his co-defendants' actions, take property of value. I think that it is without question $50,000 is property of value, and that it was taken from Jase Envoy. Was it taken by force, violence, assault, or putting in fear? This is a common sense approach. Jase Envoy was leaving Riva Motorsports, trying to make a right-hand turn out of the parking lot when two armed gunmen jump out of a vehicle that's blocking him and on each side shove guns in his face. That qualifies as by force, that qualifies by violent, that's also an assault, and I would submit to you that in those final moments of his life before he was killed, he was put in fear. 3, the property taken was of some value. I think it goes without question that $50,000 is valuable. And we know that it was money that he had on him because it just went to the bank. You heard from Cecilia Ramos, who was the bank teller, who said, and you saw the surveillance that she dispensed $50,000 to him in cash. You saw that he put it in his Louis Vuitton bag, and that same bag he had when he went from Bank of America to Riva Motorsports, and that's what was stolen. And the taking was with the intent to permanently or temporarily deprive Jase Envoy of his right to the property. I'm not saying this to be flippant. That money was taken and never intended to be given back. That's how you apply that. Was it permanently taken from him to deprive him of his right to it? It was his money, taken from his bank account. And they intended to steal it from him and not return it, obviously. With respect to Michael Boatwright took certain property of value from the person or custody of Jase Envoy. Force, violence, assault, or putting in fear was used in the course of the taking. So that's 2 ways that you can find it, either with him as a principal, or if you also determine that he is the shooter and the taller of the 2 gunmen, he's the one on the driver's side that was shoving a .22 caliber rifle in Jase Envoy's face. I submit to you that that's forceful, that's violent, that's an assault, that's putting Jase Envoy in fear to steal the money from him. The property taken was of some value, and the taking was with the intent to deprive the victim of his right to the property or any benefit therefrom. For Trayvon Newsom took the property of value from the person or custody. If you find, and I submit to you that we've proven, Trayvon Newsom is the second gunman. He's the one that ran around to the passenger side and actually went inside the car and took the Louis Vuitton bag as his co-defendant is holding the victim at gunpoint. So either you find that we've met that element as the person that did that, or as a principal, because remember, as principals, they have done this without each other. I submit to you, force, violence, assault was used in the course of the taking, and the property was of some value, and the taking was with the intent to permanently or temporarily deprive Jase Envoy of his right to the property or any benefit from there. You're going to get an opportunity. Well, 2 things I want to talk about before we talk about lesser included offenses. The state is, I'm submitting to you that we have proven the highest offenses charged in the indictment: first-degree murder and armed robbery as to each defendant. You're going to get the option that if you find that the state hasn't proven the first-degree murder or armed robbery, that there are what's called lesser included offenses that you could deliberate on. I and Ms. Buckaloo are asking you to vote guilty on the highest offenses that are charged, which is first-degree murder and armed robbery. But in the event that you want to have other options, this is how I like to explain lesser included offenses, because it's kind of hard to grasp. So, this is a Russian doll. There's nothing particularly special about it. This is first-degree murder, okay? This would be the highest offense. Contained within first-degree murder is second-degree murder. All the elements would be met for second-degree murder, okay? And contained within second-degree murder is manslaughter. Okay? So just a visual for that. And so each crime that's charged contained within robbery, armed robbery, or robbery, petty theft, and assault. Okay? We're asking you to find the defendants guilty on the highest charge. Okay? But you'll get the options. And so let's go over some of the options that you're going to get. And it goes without saying, we believe that, Ms. Bucklew and I believe that we have proven to you that the defendants are guilty of the highest degree charge, but by that virtue, they're guilty of all the lessers as well. So second degree murder is one of the options that you'll get. To prove the crime of murder in the second degree, the state must prove same element, Jose Envoy's death. The death was caused by the criminal act of the defendant, and there was an unlawful killing of Jose Envoy by an act eminently dangerous to another and demonstrating a depraved mind without regard to human life. That's a mouthful. What does that mean? So when we talk about that moment that the defendants are holding the victim at gunpoint and shoot the victim, was that a depraved mind, demonstrating a depraved mind without regard for human life? I submit to you it is. Shooting someone in the neck and then leaving them for dead. Manslaughter, that's another option you're going to get. Jose Envoy is dead. The defendant intentionally committed an act or acts that caused the death of Jose Envoy. So it's two elements. No intent is needed. Just simply, did the act cause the death of Jose Envoy? And I would submit to you it did. For armed robbery, you're going to get the option of petty theft. To prove that, the defendant knowingly and unlawfully obtained the property of Jose Envoy. Yes, like we went over with armed robbery, that it was unlawful to take it by force, violence, or threat. And that the defendant did so with the intent to either temporarily or permanently deprive Jose Envoy of his right to the property or any benefit. Like we talked about with respect to armed robbery, I would submit to yes. Assault. To prove the crime of assault, the state must prove the following three elements. The defendant intentionally and unlawfully threatened either by word or act to do violence to Jose Envoy. I submit to you that that's proven. The act would be holding the victim at gunpoint. At the time, the defendant appeared to have the ability to carry out the threat. Absolutely. Not only did they have the ability, they did. The act of the defendant created in the mind of Jose Envoy a well-founded fear that violence was about to take place. I submit to you, yes. Jose Envoy was likely in fear that violence was about to take place, and it did. So let's talk about the evidence that has been proven by the state. One of the first exhibits that you saw is the driver was Dietrich Williams. That's State Exhibit 4. Trayvon Newsom was the shorter of the two gunmen. And when we talk about height, you've sat with us for several weeks and you'll be going in and out. When the defendants stand up and out of respect for you, you can look at their height difference. You can see that Michael Boatwright is the tallest and that Trayvon Newsom is the second tallest. And you can gauge for yourself by looking at them in this courtroom, does that comport with the testimony that you heard? Michael Boatwright, Exhibit 6. You'll recall, these pictures were introduced because the witnesses identified all four co-defendants, including Robert Allen, which is State's Exhibit 7. And before I move on, the thing that you'll note, like I talked about in opening, the differences between the four. Robert Allen is the heaviest set out of the four. Michael Boatwright is the tallest. That's consistent with the surveillance as the gunman who's on the driver's side of the victim being the shooter. The second gunman is the second tallest, and you can see it when they stand up. Dietrich Williams is the shortest by far out of the three co-defendants. You first heard from Cecilia Ramos. You'll recall that she is the Bank of America teller. She dispensed $50,000 to the victim. Bank of America video surveillance was entered through her as Exhibit 1. And let me just note this. I may not go over every single piece of evidence and detail. This is meant to highlight, okay? We entered 78 pieces of evidence. You've heard from way more witnesses than I may mention, but this is to highlight so that we can go through the evidence and talk about how it's proven that the defendants are guilty of first-degree murder and armed robbery. She testified that the victim put the $50,000 in his Louis Vuitton bag, and that was also corroborated because you saw it on surveillance when he was at the counter. She described the victim as being in a very good mood. There was no beefs or anything like that happening that day. He woke up, he decided that he was going to buy motorcycles and went to the bank to get cash from his account. And that $50,000 is what was stolen and of value. Okay, so that applies to those counts that we talked about with respect to what was stolen being of value, the armed robbery, the armed robbery elements. And that's how you can determine that, because you can look at her testimony and say, okay, this bank teller, if you find her credible, she says, and I saw in surveillance that $50,000 was dispensed to him, and that's how I submit to you. We've proven that that's what was stolen and of value. And as I said, it goes to the felony murder element and also armed robbery element. Leonard Kerr, you'll recall, he's the uncle to the victim's younger brother. I think in opening I called him kind of like a step uncle. He met the victim at Bank of America, and he was asked there by the victim's mom in order to accompany him so that if the victim did buy a motorcycle, that he would have someone to drive back the motorcycle and then someone to drive back his car. He drove to Riva Motorsports with the victim, and he was witness to the armed robbery. He detailed to you how the attack occurred, and that's corroborated by the surveillance, because as the passenger, he said out of nowhere, coordinated attack. Remember the principal theory again? They're cutting the victim off. And that you can see that from the surveillance, which I believe is Exhibit 2. He describes a taller gunman as being on the driver's side. That would be Michael Boatwright. And he detailed how the gunmen were yelling at the victim, cursing at the victim. This is when we talk about, was it by force, by violence, the assault. This is how the property was taken, in addition to at gunpoint. Jesse Bukachian, he's the Riva employee who was at the counter, and he positively identified Dietrich Williams in the photo lineup in State's Composite Exhibit 10. If you'll recall, he's the one that at the counter was saying that he was selling a mask to Dietrich Williams, and he identified him as the person that he sold the mask to. And you can see that also on surveillance. Terry Yoakum, another Riva employee, he was the other one at the counter. He positively identifies Dietrich Williams in the photo lineup, and he even knew him personally and called him Chucky, or Tattoo Chucky, something to that effect. He identified also, this is important, Keith Graley. You'll recall, Keith Graley is the taller gentleman that was wearing camouflage at the counter, that was conversing with Dietrich Williams. And he identified them and remembered what they were talking about. And that it was recalled some conversation as being like lighthearted, talking about cars or motorbikes or whatever. Scott Barbeau. How can we forget Scott Barbeau? Scott Barbeau is one of the Riva Motorsports customers that was that was outside. He was eyewitness to the homicide. He described the shooter as the taller of the two gunmen, okay? And that's one of the things you can look at. Is the testimony and the evidence that you heard consistent with each other? Several witnesses all described the shooter as the taller of the gunmen. The taller of the gunmen is Michael Boatwright. And Layla Khan, who was with Scott. She's another customer. She said that she was also eyewitness to the homicide. And she described the shooter as a taller the gunman. That's more corroboration with the evidence. Marco Gruetta, who was also outside. He was the employee delivering the watercraft, if you recall. He was eyewitness to the homicide and described the shooter as a taller the two gunmen. He also described yelling and that the victim was punched before the shooting. And this goes to the force, the violence. This was a violent event in order to take the victim's money and to kill him. Yeleni Delgado, after the victim was shot and killed and his money was stolen, she's the Just for Sports manager that helped Dietrich Williams pay for nearly $800 of merchandise that he bought the next morning within 24 hours after the homicide. She authenticated the Just for Sports surveillance video, which was State's Exhibit 19. She also authenticated the receipt, so you're able to see the date, the time. This is consistent with the surveillance video, which is State's Exhibit 20. And you can see the things that he purchased. Pay special attention to that, because does it appear that it's someone that's just going shopping like any normal day? Or look at all the different sizes that he bought, all the different things. It's almost like in a frenzy, like maybe it's not his own money, like maybe he just stole the money. A 4XL of this, shoe size 8.5, and then another shoe size, and it's almost like he's just buying out the store, as opposed to maybe this is a common sense approach. When you go and you purchase things for your family or for yourself, would there be all these varying sizes? It wasn't even Christmas, this was June. You heard from records custodians, Ricardo Leal, who entered the records, cell phone records of all three co-defendants. Alex Fife, who entered the full surveillance, and that's important because you have two pieces of evidence, what we call the best of, which is the highlighted reel from Riva, but you can also, if you wanted to, go back and look at the full surveillance. And that's important because on the full surveillance, remember we pulled it up from State Exhibit 49, we see Keith Grayley leaving. And that's important because Keith Grayley was not the shooter in this case. He actually left in a white Civic before the defendants were even lying in wait for the victim. And that's on the full surveillance. Doris Paschel, she's the apartment manager that entered the full surveillance from Driftwood, which was State's Exhibit 57. You also heard from Tanisha Clark. She did not know the parties, but she was the Dodge Journey owner and rented the Dodge Journey to Tony Robinson the night before the homicide. She rented it and positively ID'd Tony Robinson in a State's Exhibit 15 in a photo lineup. She positively identified Michael Boatwright. And remember, this is important because she was given two lineups. This was a fluid investigation. At the point where they weren't sure who all the suspects were, they were receiving names. They received the name of Will Boat or Boatwright, something to that effect. So they pulled a photo lineup of two Boatwrights, Ronald Boatwright and Michael Boatwright. And this is important because Tanisha Clark, consistent with the other testimony and the other evidence that you heard, identifies the correct Boatwright. Okay? So this is not something that should be considered as doubtful on her part. It should actually be considered as positive evidence of and beyond reasonable doubt that she identified the right person in this case. You also heard from Tony Robinson. She originally identified herself as Dietrich Williams' sister or cousin or something to that effect, but she's essentially told you guys she's his close friend. And she identified Dietrich Williams in court as the person who she rented the vehicle for. She identified Trayvon Newsom. She identified Michael Boatwright. And she rented the Dodge Journey for Dietrich Williams, Michael Boatwright, and Robert Allen, another application of the principal theory, where the three of them are utilizing someone to accomplish getting the car rented. And before I move on, think about this. The renting of the car, and this is a common sense approach, what purpose was that for? It wasn't to go to Disney World. It wasn't to hitch a trailer to it so that they can go motorbike riding. Because as you've heard, there's some testimony that Dietrich Williams liked to ride bikes. There were no motorbikes that day. Instead, the four of them are together in this car that was rented for one day and one day only, not for a trip. They remained in Broward County, armed with firearms and masks, and it's just as you were told during the testimony that it was to rob people that day. You heard from Detective Marshall Wolcott. He was one of the crime scene detectives. He took into evidence the removed projectile. It was a partial projectile, which is states 37, from the victim at the hospital. He also entered the projectiles that were collected from the victim, from Dr. Boyko, collected 2 projectiles from the victim at autopsy, which was entered into evidence as states 67. The victim's necklace with observable blood on it. And you're going to be able to take these things back with you to the deliberation room. It's in plastic because it's biohazard, but you can see, I know there was some testimony back and forth about, well, can you see blood? There's blood on it. You can still see it 5 years later. States Exhibit 38. He also collected buccal swabs from numerous witnesses, fingerprints, the cloth mask, which was important to this case, is States Exhibit 44. The neoprene mask, States Exhibit 55. The swabs of the mask, which were later tested by Nicole Eyman, States Exhibit 48. This is important, the blue book bag that was in a Cadillac in front of Michael Boatwright's home. Now, I submit to you that it was hidden. It's in an inoperable car, shoved behind things near a wheel well, and within that book bag, which was States Exhibit 43, within this book bag, you have 3 boxes of .22 caliber Aguila brand ammo. You have the mask. You have items that were almost like a kit to rob people, hidden in the Cadillac in front of Michael Boatwright's home. In that, which is important, we're going to talk about in a second, 3 boxes of .22 caliber of Aguila brand ammunition, which was entered as States Exhibit 46. And you'll recall, it's displayed for you like this. Okay, and we'll talk about this in a second. And Tennille Carter. She identified herself originally as Tennille Williams because she was engaged to Dietrich Williams. She's his ex-girlfriend. And it's nothing, I know the saying goes, there's no woman like a woman scorned or something like that. She's not scorned. You can tell that even after they were broken up, she still tried to help, because remember, her testimony was that Dietrich Williams tried to get her to change or adjust her testimony to help him out by saying he was not the driver of the car. She positively identified Dietrich Williams in court. She identified Michael Boatwright in court and in a photo lineup, which is States Exhibit 13. She identified Trayvon Newsom in court and in a photo lineup, which is States Exhibit 14. She identified Robert Allen, States Exhibit 12. And she testified how they were frequently together. And she didn't try to oversell her testimony. She didn't say that they were all best friends and that they were hanging out every day. She told you. She said, you know, I saw Trayvon Newsom, not as much as I saw the others, but Michael Boatwright and Robert Allen and Dietrich Williams were together. Pardon the pun, thick as thieves, okay? She also told you how Dietrich Williams persuaded her to write Judge Uson to state that he was not the driver. And think about that. Who does that benefit? It benefits Dietrich Williams. If there's something out there or an affidavit that says that he's not the driver. And she detailed how Dietrich Williams told her that he was there. And that's, you'll recall, one of the 2 times that Dietrich Williams is telling someone, because the other time is Detective Curcio, that he was at Riva during the homicide. And she also detailed that he witnessed the homicide and the robbery. He said that there were 3 people that were involved, okay? And this is important because this is close to the time that Mr. Onfroy was killed. It's not 5 years later. It's not, he didn't tell her that there were rappers involved and that there was some conspiracy theory. He tells her 3 people were involved. He was there, and he was there at the time of the homicide. And what do we see from the surveillance? And that we know, and I'll get into that a little later. We know he was there because his phone puts him there as well. We know he was there because we see it on surveillance. We see him there. Detective Clint Williams. He's a lead crime scene investigator. Crime scene photos were introduced through him. DNA swabs. This is important. 2 fired casings from the crime scene, State's Exhibit 30. You recall, those were the ones that were right by Mr. Onfroy's BMW that were collected. Cell phones from Dietrich Williams' residence, which were later, we later did analysis on. And this is very important. A live .22 caliber, single .22 caliber live bullet from Dietrich Williams' master bedroom, State's Exhibit 29. He collected latent fingerprints. The victim's jean jacket, State's Exhibit 34. The sweatshirt. Which is State's Exhibit 35. And this is important because this is consistent with the other evidence that as Mr. Onfroy was seated in the front seat, the defects in the sweatshirt are showing that he was shot in his neck 3 times. State's Exhibit 34. Also consistent with the defects in the clothing and the testimony that you heard from the medical examiner that Mr. Onfroy was wearing this clothing, and the defects are consistent with him being seated in the driver's seat and being shot in the neck. These are all things, if you recall, when Dr. Boyko was on the stand, and I stood right here and he was pointing out where the actual injuries were. Remember, injury A, B, and C. Those are all consistent. And these are things, as you're evaluating the evidence, does the testimony and the evidence agree with each other? Is it consistent with each other? These are things that you can look at and take into consideration. Detective Williams also was, he also had evidence from the autopsy that was submitted to the lab. Detective Walter Foster, he executed the search warrant at Dietrich Williams' home. The orange slides with the socks, those were taken into evidence. And these orange slides, we've seen these a number of times on Dietrich Williams in surveillance, not only at Riva Motorsports, but again the next day at Just for Sports. Seems to be his favorite slide. Dietrich Williams' cell phone, State's Exhibit 55, which was analyzed. Buccal swabs. The camouflage hat with red brim, the infamous camouflage hat with red brim that we see over and over and over again on Michael Boatwright and all of the dozen or so videos that he posted after the homicide, wearing this, if you'll recall, a black champion or something to that effect, hat or a shirt. Videos downloaded from Dietrich Williams' cell phone. The Reva receipt for the mask purchase. Dietrich Williams' social media pictures were also entered into evidence. Detective John Curcio, he was a lead detective. He also re-entered in through him Michael Boatwright's cell phone, States Exhibit 63. DNA swabs. And you'll recall, he interviewed Dietrich Williams. Dietrich Williams denied at first being at Reva and said that he wasn't even there. He gave 3 different versions. He then said, okay, fine, I was at Reva with my kids. Also a lie. Okay, fine, I was there during the homicide, which is what he also told Tanel Carter. And you'll recall, through Detective Curcio, we learned that Dietrich Williams changed his story 3 times. And this is immediately after the homicide. No evidence or statements about any rappers involved, anybody from another country, rap beefs, Twitter beefs, nothing. He talked about him and 3 people being at Reva. He lied repeatedly, and you can take that into consideration as a consciousness of guilt. Is he trying to show that he wasn't there to minimize himself, like when he's trying to get Tanel Carter to change her testimony? And again, he never mentions any rappers, any rap beef as being part of this homicide. Detective Curcio also executed a search warrant at Trayvon Newsom's residence because of a text message and evidence linking Trayvon Newsom to the co-defendants. And you'll recall, it was in John Curcio's testimony that he said that the text message read, I buried it at my house, and I get you pregnant and stay out here, and soon gone, have to dig up the money. I got the $8,000 buried. Real shit. I be thinking I'm gonna catch life, but I bury that bitch. What could he be referring to? Maybe could it be the money that he was posing with within 24 hours after the homicide that we'll see out of Michael Boatwright's phone, saying that he's catching life, saying that he got snitched on. And that phrase is important. You know why? Because we learned in this very trial, Trayvon Newsom, out of all 3 co-defendants, had the nerve and the gumption to threaten a witness that's testifying, while the witness is still under oath and testifying for you during the days that he was here. And just like he says in that text message about somebody snitching on him, what does he do? As soon as he can get within earshot with that witness, he calls him a bitch. He calls him a snitch. He says that he's working for the white man and that he's working with the popo. That's consistent with the testimony that you heard from Trayvon Newsom, or about Trayvon Newsom. Nicole Einert was the DNA analyst who, she analyzed swabs. Remember we talked about the unknowns and the knowns. And the neoprene mask, the swab of the neoprene mask, which was states 45, and the swabs are from states 48, she identified that. Remember the numbers, it was like 1,000, 1,000,000, and all the way up to octillion, identified to Dietrich Williams. DNA on the swab of the black cloth mask, I think that was not octillion, something, a number that was even more zeros added, identified to Michael Boatwright. And you'll recall, this is important because I know that there was testimony that at least one of the co-defendants was an avid bike rider, okay? And you saw testimony, or you saw evidence that was entered as a defense exhibit. I believe it was Michael Boatwright's defense exhibit of Michael Boatwright with the mask. But that day, you'll recall, think about the other evidence that you heard in the common sense approach. Beatrice Williams and Michael Boatwright were put at the scene of the homicide, during the homicide, by the location dial of their phone. They weren't bike riding. They weren't at work tattooing. Michael Boatwright wasn't at work doing landscaping or whatever it was that he was doing at the time. They were at Reba Motorsports committing this armed robbery and homicide. That's the significance of that evidence. The DNA swabs, you'll recall, she identified two, Genesis Sanchez, from the victim's car and from the victim's fingernails.
I'll object that that's not evidence, that was not our testimony.
Jury will rely on its own recollection and testimony. You may proceed.
DNA swabs from inside the Dodge Journey, the AC controls, she identified it to Robert Allen. And she did say to you, she didn't try to oversell her testimony, that there was no DNA on the necklace or the victim's neck.
Again, objection, that's not evidence.
Overruled. Jury will rely on its own recollection.
However, there was no foreign DNA on the victim's neck and the necklace. And so consider,
Objection, that's not evidence.
Overruled.
consider this. There's going to be a lot of argument as to whether or not you can find the defendants guilty of first-degree murder and armed robbery because of the absence of DNA on the victim's neck. But there aren't, if not them, then who? Because there isn't any DNA. And so remember, I touch this podium, I actually touch it a lot as something that I do when I walk around and I'm talking. And I asked Ms. Einat, if I'm touching this podium, is there any guarantee that there's going to be DNA that's detectable from me touching it? It doesn't mean that I didn't touch it if you don't find my DNA there. That's not what that means. And so when you're thinking about this evidence, consider it not as this like smoking gun that's like, oh my gosh, these defendants are not guilty because there's no DNA on the defendant's or the victim's neck. It should be considered with all other evidence because there's a lot of other very compelling evidence that does prove their guilt. And the absence of DNA does not mean that Trayvon Newsom wasn't grabbing at the victim. It doesn't mean that Michael Boatwright wasn't punching the victim or shot the victim. So consider that as you're evaluating the evidence. And you'll recall that she said the absence of DNA does not mean you didn't touch something. The identity of the victim was only stipulated by one co-defendant, and the stipulation was read by Judge Uson. That was
Object to that, Commissioner Sidewalk.
Parties may be seated. Court will come to order. The parties are present. The jurors are present. And gentlemen, you want the back state.
All right, ladies
Proceed.
and gentlemen, thank you, Judge. After this brief technology break, I hope that you were able to use the bathroom. I'll call it an intermission. I think we got the technology working. So one of the things that we were last talking about was that the location data from Michael Boatwright and Dietrich Williams' movements from 117 to 520, and that's important because not only does it include the time of the homicide, but it's a big window because it shows how long they were together. So when you think about principals and how they assisted each other, and remember, there are no obvious stops, picking up or dropping off Trayvon Newsom, and we'll get into how we can prove that he obviously was with them the entire time. Look at this location. Sorry. Okay. And you'll recall, this was the animation that Mr. Campani put together with the location data from Cellhawk program, where it shows the phone in purple is Mr. Williams's phone, together with the phone that's notated in red as Mr. Boatwright's phone. The entire time they're together. And think about the other testimony that you've heard. Mr. Boatwright's phone is connected to the Dodge Bluetooth the entire time. There they are, traveling to Riva Motorsports where the homicide occurred, remaining stationary during that entire time that you see the car on surveillance. And I would submit to you committing the homicide during this time. And this is important because you don't see the phones separate, which shows that they were together. You don't see Mr. Boatwright's phone at some other location like his grandmother's house. You see him at Riva Motorsports the entire time during the homicide. Consistent with the other testimony that you've heard, you see the phones arrive at Mr. Allen's home, just like the testimony that you've heard that they all went to Mr. Allen's home to divvy up the $50,000 that they just stole from the victim after they killed him. And here they are arriving at Mr. Allen's home where they remain. And notice, when they left the homicide location, there were no stops in between. And we know at Mr. Allen's home, who's with them? Trayvon Newsom. Because Trayvon Newsom, you'll see, appears on surveillance with Michael Boatwright.
at how long they are at Mr. Allen's home. Think about how long it takes to count and separate $50,000 amongst 4 people. And how do we know they had that cash? Because we're gonna see the evidence, how they all bragged about having the victim's stolen cash afterwards. This is also the time where I submit to you, you're getting rid of the firearms. Remember, they were never recovered. And while we see Michael Boatwright stay at Mr. Allen's home, consistent with the testimony you heard, there goes Mr. Williams leaving. Now, could have been by Uber, whether he called somebody to have the Uber called for him, we don't know. Mr. Campani didn't oversell his testimony. He said could have been one of those unknown numbers. But what we know is the location data is consistent with the testimony that Mr. Williams leaves the 3 of them there and then returns back to his house. And so during the most important time, which is the time of the homicide, the location data does show that the 2 defendants' cell phones, which I submit to you was in their possession and in their hands the entire time, shows them at the homicide location, consistent with the surveillance. And we know this because as we see the location data showing them arriving at Riva, we also see the Dodge Journey, which is connected to Michael Boatwright's Bluetooth, arriving at the exact same time. And we know that the phone was in Dietrich Williams' hands because very shortly you're going to see him get out of the car and go inside with those very same orange slides that are in evidence, where he's then seen in the surveillance, in the Riva Motorsports inside the store, scoping out the scenario to tell the others that they spotted the victim inside. We also know that during that entire time, also connected to the Bluetooth again, Michael Boatwright's phone, the entire time connected to that Bluetooth, it matches with the departure from Riva at the same time. And so that's important because they didn't get out the car when there was a sedan that stopped in front of the car while they were lying in wait. They didn't get out the car when there was a car backed up next to it. If you recall, they're in that van, lying in wait to rob and kill the victim. And just like the location data shows, they're departing at 3:56, consistent with the surveillance, showing them leave immediately after the homicide. Consistent with the location data, here they are arriving at Robert Allen's home. If you recall, that's the exact track that the location data shows. And what do we see on surveillance from the exhibit from Driftwood Apartments? There it is, the Dodge Journey, connected to Michael Boatwright's Bluetooth. He's in that car, ladies and gentlemen. That's the common sense approach. His phone isn't traveling in the car by itself, it's in his hand. He's in that car, connected to the Bluetooth with Robert Allen and Trayvon Newsom and Dietrich Williams. And there's the Bluetooth connectivity that Mr. Campvani told you about. Michael Boatwright's phone, the connection started at 3:25 p.m., just before the homicide. It doesn't disconnect until 4:28. That's the exact time of the homicide. You also heard from firearms analyst William Ruiz Fontanez, who analyzed the 3 boxes of the .22 caliber Aguila brand ammo that was found in Michael Boatwright's home, hidden in that backpack in the inoperable Cadillac, and that states Exhibit 46. It's consistent with the caliber and the brand as states 67, states 29, states 30, and states 37. And Mr. Ruiz Fontanez compared and analyzed the 2 projectiles that were recovered from the victim at autopsy, which is state 67. He also compared, which is important, the live .22 caliber, that single bullet that was, I submit to you, kept as a trophy or whatever, that was at Dietrich Williams' home. Okay? And this is how, when we talk about principle theory, look at all the evidence that connects them. 22 live at Dietrich Williams' home. The 3 boxes of .22 caliber Aguila at Michael Boatwright's home. The 2 fired projectiles from the victim, analyzed and compared also from the fired casings that were on scene. And it's concluded that those exhibits, 67, 29, and 30, were cycled through and fired from the same firearm. That's important, ladies and gentlemen, and I can't underscore this point enough, because that means that evidence from Dietrich Williams' home, the fired casings that were found near the victim's car, and the fired projectiles are from the same murder weapon. And so even though the defendants tried to get rid of the firearm to try to avoid detection, what they left behind still connects them to the homicide, because all of that evidence was cycled through the same firearm. That's the importance of what was left behind. And there's something else to note. The 3 boxes of .22 Aguila brand ammo from Michael Boatwright's home, which is State's Exhibit 46. If you'll recall, there's supposed to be 40 in each box. You can count them. You can take this back with you. You know how many's missing? 4. Only 4. And the only 4 that are missing, 1 is the partial that was taken from the victim at the hospital when there were life-saving measures, which is states 37. That's one of the missing ones. The other is the fired projectile recovered from the victim at autopsy. That's the second missing bullet. The third is the fired .22 caliber projectile recovered from the victim's body at autopsy. Remember, there were 2. And then the live bullet recovered from Dietrich Williams' home. So there's 2 projectiles recovered from the victim, a partial that came from the victim, and then the 4th was at Dietrich Williams' home. And all of this evidence is connected to Michael Boatwright's home. Only missing 4. That's not a coincidence. That's not a guess. You can count them. 2 plus 2 equals 4. let's talk about, because I know I've talked a lot about, for example, robbery and felony murder, but you can find still that these defendants, if you choose to find that they were guilty of premeditated murder. Let's talk about premeditation. Premeditation is killing with, after consciously deciding to do so. The decision must be present in the mind at the time of the killing. And the law does not fix the exact period of time that must pass between the formation of that thought and which is the premeditated intent to kill, and the actual killing. So it doesn't have to be weeks. It doesn't have to be months. It can be you form the thought and you do it. It can be you jump out the car, you point a rifle at someone, and that thought is formed, and you shoot, and you pull the trigger, and you kill them. That could be your premeditation. And so in this case, I actually have more than just a moment of premeditation. 8 minutes, 35 seconds. So 8:35:61 is the exact amount of time that the defendants were lying in wait. You remember, after Dietrich Williams and Robert Allen come from inside Riva and they confirm XXX is inside, then they go with, all four of them are now in the Dodge Journey. You remember, you heard testimony. They all went in the car and then they parked across the street from the vantage point to be able to see the victim's BMW i8 and wait for him. And they waited for him for 8 minutes, over 8 minutes, almost 9. And so if I say to you, 8 minutes, it could mean anything. We use that time frame. I'll be there in 10 minutes, like it's nothing. But 8 minutes, when you're waiting to take someone's life and by force shove a gun in their face, is an eternity. So let's see how long 8 minutes feels in 35 seconds. 8:35:61. So ask yourselves, that's more than enough time to formulate the premeditated intent and the design to kill someone and the killing. More than enough. It's an eternity, practically, it feels like. And think about what the 3 co-defendants were doing during that time. Look at how long that time is, as they sat there and they waited and they confirmed and looked up Jose Envoy's vehicle and his pictures from the social media to make sure that it was him. And they sat there and they waited across the street.
Objection, Judge, matter evidence.
Overruled.
With a vantage point just close enough to see the victim's BMW. But they think far enough that it's out of the sight of surveillance. And they sat there and they decided amongst themselves who was going to jump out. It wasn't going to be Robert Allen. It wasn't going to be Dietrich Williams, because Dietrich Williams was the driver. And so during that 8 minutes and 35 seconds, Michael Boatwright is putting on his mask. Trayvon Newsom is putting on his mask. They're covering their heads with hoodies. They're making sure that the firearm is loaded, the .22 caliber rifle, the handgun that you heard testimony that Trayvon Newsom had in his hand. And they're waiting for that whole time. And during that time of eternity, Mr. Envoy is inside Reba. Doesn't have a clue that any of this is about to happen. That he only has 8 minutes and 35 seconds left to live. And so while he's in there with his own money, trying to purchase a motorcycle, and he comes out with Leonard Kerr, that 8-minute clock is still ticking as they're waiting, almost as if predators, just waiting for their victim to come out. And as he's walking out and they spot him, the car's on, in drive, ready for Dietrich Williams to punch on the gas and immediately cut the victim off as he's trying to exit the parking lot. That's what's happening during that time. That coordination of as soon as the car stops in front of the victim's car, the two passenger doors slide open. And what do? They jump out with their firearms that they know are loaded and ready to go, ready to fire. And each one goes on the side of the car to rob and to kill the victim. And I submit to you that that is more than enough time for premeditation. You don't have to take my word for it. You can see it for yourself. That evidence, ladies and gentlemen, is evidence of both premeditation and felony murder. You also heard from Deputy Alvarez, who took the stand and testified that he escorted Robert Allen to court. We made no bones about it. Robert Allen was in custody. Robert Allen came with his own host of baggage, right? But while he was being escorted to court, Trayvon Newsom, and you'll recall Robert Allen testified about it, but it was also corroborated by Deputy Alvarez, pointed out Trayvon Newsom as the one defendant who intimidated Robert Allen. Think about the nerve that it takes to be able, while somebody's with a BSO deputy, to threaten that person in the deputy's presence. Think about that for a minute. And that's not somebody's discontent because, hey, my friend is testifying against me. No. The common sense is he's on trial for first-degree murder. And just like the text message says that he was snitched on, he is pissed that Robert Allen came in front of you and is testifying and pointed him out as the gunman. And so even though in court he's wearing a three-piece suit and he's quiet and demure, as soon as he gets the opportunity, what does he do? He starts yelling. Yelling at Robert Allen without any provocation, calling him a bitch, saying that he's working for the popo. He's working for the white man. And he's positively identified as the person who did it. Why would somebody do that? Why? It is called consciousness of guilt. Because if you know that you murdered someone and you're on trial for that murder, you're not going to say to the person, oh, you know what? I'm upset because we used to be friends and I stayed at your house. He didn't say, why don't you tell him who really did it, Robert? What does he say? You're a snitch. He calls him a bitch, yelling all the way till he can't see Robert Allen anymore. That's consciousness of guilt. Trayvon Newsom's guilt. The other things that you can look for Trayvon Newsom's guilt, remember, he's the one that got a ticket for the crash that happened in Fort Lauderdale. Irrefutable that he was with the co-defendants that day because it's been said over and over, even by his own attorney through questions, He willingly went back, he said, to the crime scene of the crash scene, and that he gave up his license as the person who was driving, even though he wasn't driving, by the way. He was in the car, but he went back to the crash scene. And he's seen on surveillance just before the crash. Remember, there's Trayvon Newsom and Michael Boatwright parking the car backwards, and when they were trying to avoid having the car in front of Robert Allen's home. That's another thing. You can ask yourself, why? If either of them are innocent of this homicide, why are they parking the getaway vehicle way down the block where nobody lives there? They're not with Dietrich Williams. They're not with Robert Allen. They're by themselves. They're 2 of the 4 killers. Why would they be doing that? He's with Michael Boatwright at the crash. And remember, Michael Boatwright's phone the entire time was connected to the Bluetooth. And there's no stops made between Riva Crash and Lauderhill, where the crash occurred. Reasonable and common sense approaches to conclude that Trayvon Newsom was with Dietrich Williams, Michael Boatwright, and Robert Allen, and is the second gunman. And Trayvon Newsom, remember, he doesn't have a job, but as we'll see, he just happens to have thousands of dollars in cash the day of the homicide. And Trayvon Newsom made the statement in the text message, or the text message says that he was going to bury $8,000 in the backyard. And last but not least, he's the one out of all of the defendants that threatens Robert Allen during the trial. This trial, when Robert Allen is testifying to you, Trayvon Newsom has the nerve and the audacity to threaten him, to try to get him, to intimidate him so he won't testify in front of you. He did that. And then, of course, there's all the videos from all of them, mind you. When we talk about how they work together, the first 4 videos are from Michael Boatwright's phone. Okay? And this is from Dietrich Williams' phone. But when we talk about how the evidence, you can view it together, look at this. The next 2 videos, pay attention and listen to the music, how it's a continuously one song in the video. And besides paying attention to that, you see the hat that he's wearing in the video? Same hat. Different than the hat that Keith Gray wore? So it stands to reason. See the vantage point? Michael Boatwright appears to be in a car, seated in a front seat. Somebody's taken that video for him. So I submit to you, that's Trayvon Newsom videoing him as Michael Boatwright shows off the victim's stolen money. And then Trayvon Newsom, just like Robert Allen told you, then passes Michael Boatwright's phone, because he used his phone. And then now he videos the threat. Same music. You can hear it with your own ears. And you can see they appear to be in the same car. And this is also important because Jim Campani testified about the metadata from each of these videos and put the location of each of these videos. And so, again, when Michael Boatwright was taking this video, the phone was in his hand, never left, the phone didn't separate from his hand. It's his phone, not a community phone. Look who's with them. Trayvon Newsome. And the location data puts them together because obviously they're together from the same song. And pay attention also to what they're wearing. And not to be left out of showing off the victim's money is Dietrich Williams. That's who they really are. Not the defendant that wears a bow tie to court at his trial, or the defendant that has the three-piece suit, or the defendant wearing a turtleneck in front of you, sitting here quietly. This is who they are. This is their real character. This is who they are.
I'll object comment about the character improper.
Overruled. Sorry.
This is their character. Killers that within 24 hours after shooting the victim dead and stealing $50,000 from him, this is what they do. Look at how happy they look. Look at how excited they look to have this money as they're showing it off repeatedly. And I didn't even put all the videos in this slide. You have it evidence. It's dozens of videos. Look at his face, how happy he looks. It's okay, you can look at him. You see him there now. This is who he is. And I submit to you, this is real money. It's common sense, it's real money. Look at it, how crisp it looks. Like it just came from a Bank of America, dispensed earlier that morning. Look at how the bills are all facing each other. As if Cecilia Ramos had just run it through the counter. And all of the bills happen to be facing the same way and folded in the same way. Those are things that you can take into account as you're looking at and considering, was this really what they did? And I submit to you, it absolutely 1,000% is what they did. The other thing to pay attention to with these videos, you'll recall the Driftwood surveillance shows, and this is something that defense counsel, for example, Mr. Newsome, admitted as much. He says that he was in the car after the fact because of the crash ticket. And so the surveillance video shows two people. Shows two people leaving the Dodge Journey just after the homicide. And again, remember I was saying to you, Michael Boatwright and Trayvon Newsome were together the entire time. No obvious stops that Trayvon Newsome was picked up or dropped off. And so here they are. Taking the suspect vehicle, parking it way up the street for no other reason other than They just committed a homicide in that car, and they don't want it to be detected in front of Robert Allen's home. And what do we see them? As Trayvon Newsom is look at what they're wearing. Look at what they're wearing. Look at the height difference. Trayvon Newsom in the white t-shirt, just like he is here, flashing the money. Here and here. Same ripped jeans. Same hat. Same black shirt Michael Boatwright has on there with the champion logo that you can see even from the vantage point right there. It's the same. And this evidence, by the way, when we talk about does the testimony and the evidence agree with each other, this is what Robert Allen testified about. He said that this is what they did. You don't have to take his word for it. You can see it on the surveillance from the driftwood. And you can see it consistent with videos from Michael Boatwright's phone. There they are. She sings from ear to ear, so happy. You will get an opportunity. I'm going to talk to you again. I'm going to be talking to you before I sit down about what you'll get when you're in the back deliberating. Okay, so besides the evidence that you're going to get to review and talk amongst yourselves, you're going to get verdict forms. And this is what they look like. You're going to get one verdict form per defendant per count. So that's 2 verdict forms, 6 total for each defendant. Okay? And so it looks just like this. The pertinent parts. The first one is for count 1. And remember, the state is asking you to vote guilty for the highest count charge, which is first-degree murder. You're going to get the options like we talked about the lessers. It's going to be on the verdict form here as B and C. But based on the evidence that has been presented to you, I submit to you that the state has met its burden as to each element beyond and to the exclusion of all reasonable doubt that the defendant, Dietrich Williams, is guilty of first-degree murder. And so, remember, during jury selection, I actually asked row by row. Each row, I asked if the state presented all the evidence and met its burden, could you vote guilty of first-degree murder? It wasn't a question that was just in futility or hypothetical. This is now real. The state is asking you to vote guilty of first-degree murder. And I asked you in jury selection if you could do that because now's the time that we presented the evidence to you, proving to you that Dietrich Williams is guilty of first-degree murder. And now is the time when you go back there and deliberate, you're going to see this verdict form. I'm asking for you to check that box that he's guilty. You will also get a verdict form for count 2 for armed robbery. You're going to get all the options that we talked about, the lesser included offenses. But I'm asking you to vote the highest offense charged in the indictment, which is guilty of armed robbery, because that's what we've proven. Trayvon Newsom, you'll get a verdict form for him for count 1. His is going to look a little slightly different. It's going to have all the options for first-degree murder and the lessers, but you'll also have a question at the end. And so, just the same, we're asking you to vote guilty, that Trayvon Newsom is guilty of first-degree murder, which is the first option, so to check that option. But then you'll also get the opportunity to ask yourselves, during the course of the crime committed, did Trayvon Newsom actually possess a firearm? That's a question of fact for you to consider, and I submit to you the answer is yes. Not only did you hear testimony that he had a revolver, but also it makes common sense. You're not going to jump out of a car to commit a robbery with no weapon in your hand. That's a common sense approach as well. And so, consistent with testimony and what you've seen is that he had the firearm in his hand. And that's what you heard from all of the witnesses, eyewitnesses, by the way. They said that the second person, the shorter of the two, also had a firearm in their hand. And so I submit to you that you can check that box as yes. That he also had a firearm in his hand. Now, for count 2, I submit to you that Trayvon Newsom is also guilty of armed robbery. And so we're asking you to check the first option, which is guilty of armed robbery. And also during the course of the crime committed, to answer this question, yes, he actually possessed a firearm as well. So you're going to answer that question twice, for count 1 and for count 2. You'll then get the opportunity to fill out Michael Boatwright's verdict form, and his is going to look slightly different from the other two. First, we're asking you to vote that he's guilty of first-degree murder as charged in the indictment, because that's the highest crime charged, and I submit to you we've proven it by all the evidence so far that we've talked about. So to check that option as guilty. Then, during the course of the crime committed, did Michael Boatwright actually possess a firearm? There's going to be 3 questions for you to answer. 1, did he actually possess it? Yes. That's what the testimony shows. That's what the evidence shows, the surveillance. Also, circumstantially, look at all the ammo he had matching to the actual firearm. There's testimony putting him as the shooter by Robert Allen is corroborated by all the eyewitness testimony saying that the taller of the two, of all of the co-defendants, was the gunman that shot the victim, so he possessed that firearm. Did he discharge that firearm? Yes. There's 4 missing ammo from that box that was found in front of his home, all connected to the firearm, all connected, which is the murder weapon in this case. And so, the second question, I'm asking you to answer yes. The third question, during the course of the crime committed, did defendant Michael Boatwright actually inflict death on Jose Onfoy as a result of discharging that firearm? Yes. He's the shooter. I've made no bones about it from the beginning. He's the one that discharged that .22 caliber rifle. And everybody had said, the tallest of the gunmen. I hope that you looked when we were on break. He's the tallest at all of them and has been identified as the shooter. And so it's his weapon that actually killed Jose Onfoy. You'll get an opportunity to deliberate as to the second verdict for Michael Boatwright. I ask that you also vote him guilty of armed robbery as charged in the indictment. Answering the same questions again. Did Michael Boatwright actually possess the firearm? Yes, for the reasons that we've stated. During the course of it, did he discharge that firearm? Yes. And the third, yes, a resounding yes, that by the discharge of that firearm, that death was inflicted on Jose Onfoy. I think that when you are deliberating and you are able to review everything and think about the credibility of the witnesses, the quality of the evidence that you've seen, you're going to go back there and you're going to think about these final thoughts. This is as to Dietrich Williams. Not only was he a principal, he was the driver. Tanel Carter's testimony corroborates all of the other evidence identifying him. Robert Allen's testimony is also corroborated by all the other evidence you've heard. He tries to get Tanel Carter to change his testimony. Tells Tanel Carter that he was at Reba. He admits that to her. His DNA is on the mask, one of the 2 masks. He's flashing money immediately after the homicide. The live .22 from the murder weapon matches the fired projectiles from the victim and also matches the ammo found at Michael Boatwright's home. His post-Miranda interview with Detective Curcio, where he lies and changes his story 3 times. He lies about Reva first being there than saying he is. And his cell phone location data putting him on scene during all the pertinent times. That he's guilty. You're going to, I believe, I submit to you, find that Dietrich Williams is guilty of first-degree murder and guilty of armed robbery. As to Trayvon Newsom, he's a principal. He's flashing money immediately after the homicide. His videos are found on his co-defendant's phone, placing him with them on the day of the homicide and during the homicide. The text message about borrowing the money. Robert Allen's testimony, putting him as the second gunman. Tenille Carter's testimony, when she identified him as being with the co-defendants during that time. He's the second gunman. Remember that consciousness of guilt. He's the only one that threatened a sworn witness that was in front of you. Surveillance footage places him with the co-defendants. The Driftwood surveillance footage. The threats to Robert Allen, the intimidation, and he's ticketed for the car crash that also puts him during that time. So he's also guilty of first-degree murder and of armed robbery. Michael Boatwright, he's the shooter. The 22 Aguila bullets match the fired projectiles from the victim's autopsy and the live 22 from his co-defendant's home. Tony Robinson's testimony as well puts him as picking up the car, you'll recall. He picks up the Dodge Journey with Robert Allen. Tenille Carter also identifies him as being with the co-defendants during this time. In addition to being a shooter, he's a principal as well to his co-defendants. His DNA is on the mask. All the evidence proves that he was a shooter and not at his grandmother's house gingerly sleeping. The fired casings on scene and the fired projectiles from the autopsy match the murder weapon. Robert Allen's testimony also is corroborated by all of this and puts him as the shooter. His location data places him on scene the entire time. His Bluetooth connectivity also has him on scene and connected there. He never left the homicide scene. He's also guilty of first-degree murder and of armed robbery. I'm going to get a second opportunity to speak to you after all of the defense counsel has had an opportunity to talk to you. And I ask you to please, as you have been so graciously paying attention to all the details that have been discussed and the evidence that's been presented to you, think about the things that we've talked about so far. I know I've been standing up here talking for a long time, but think about these things as you listen to the additional arguments and keep that common sense approach and keep that in mind, that these defendants are guilty of the two offenses that we have charged them with. And I'll wrap up when I get that second opportunity to talk to you. Thank you, ladies and gentlemen.
Thank you, counsel. Ladies and gentlemen, it is 1:15. I think it'd be a good time to take a break. Clear your heads a little bit. Relax. Come back in 1 hour. Come back in 1 hour. And that's attorneys will have their opportunity to present closings. Once again, as we keep time to break, I will remind you you're not to form any definite or fixed opinions in your case until you hear all the evidence. The arguments all counsel and questions in law might be. Until that time, do not discuss cases among yourselves. During the course of the trial, take regular recesses. You wish your committee to separate to like personal affairs during these recesses. You will not discuss a case with anyone nor permit anyone to say treat in your presence. Attempts to, the jury has to stop and to leave them at lunch or command one of my deputies. Counsel, this is associated with the case in the hallway. We will
ignore you, they're not being rude, they're following the court's orders. Have a good lunch, see you tomorrow.
I buy the same products you do. I buy the same products you do. I buy the same products you do. I buy the same products you do.